Hello there, ladies and gentlemen. I haven't seen you guys in a little while. I've been kind of bummed out over these Epstein files. I don't know how you guys have been kind of processing that stuff. It's been something that I've kind of always known about. You know, like I said, I put a post up recently saying that, I have been kind of aware of a lot of this stuff. Like I watched Zeitgeist was the big wake up for me back in 2007, I think it was 2006 or 7. There was a documentary called Zeitgeist. That was the one that kind of really kind of woke me up to a lot of this stuff. Not quite this stuff, but to some degree, kind of craziness going on. But yeah, anyways, just been kind of processing a lot of the information that's been coming out about the Epstein files and stuff like that. It's been kind of like, whoa, kind of overwhelming. It's kind of one of those things you don't really want to think about, even though, like, for most of us, we probably are aware of what's going on. And it's kind of like, well, what are we supposed to do about it and this and that? So, we're supposed to just do what we're doing and continue to get people aware of, negotiable instruments as well as the whole citizenship thing. I really think that's still the correct track for us and what we're doing and that kind of thing. I wanted to mention for anyone that has been reading my book and they have not left a review, if you could go on to, this is my book for those of you that are not aware, if you could please go on Amazon and put a review for my book, I'd really appreciate that. You can click the link here, or you can find it on Amazon. For those of you who have verified purchases, it really helps me a lot. With that said, today I wanted to get into the discovery that I did. It's been a little while since I did it. I usually like to do the videos kind of like the same day, but didn't work this time. I got kind of sidetracked with all this other stuff and got kind of bummed out a little bit. So just been processing that information, all the information that's been kind of dumped on us in the past couple weeks. And so kind of back here, we're going to see, hopefully they're going to file into this case. This is for the City of Glendale case. For those of you that aren't aware on how to get into these cases, you're going to go to williamsandwilliamslawfirm.com. You're going to go down to current and previous litigation. You're going to go all the way down to the bottom, which is the newest case. Case 13, City of Glendale Round 3, California State Court. And then it's not a recap thing. It's not a federal case. It's a state case. So I just have a Dropbox folder. And you click that, and then boom, you come in here, and you can see all of the filings, docket item 1, 2, 3, and then this is the discovery packet we're going to be going over right now. I have it right here. So this is the discovery packet. A lot of you guys have asked me kind of how did I come up with, discovery questions, or you guys are in a case in discovery, and you guys have I don't know how you couldn't have 10,000 questions. So when you guys ask me those kind of questions, it just makes me wonder if you guys have any idea what's going on, because, this is the only part that I really had to work on at all was just making sure that the questions were formed properly so that they wouldn't get rejected by either the defendant or the courts. Besides that, I don't know how you guys couldn't have 9,000 questions. But anyways, we'll go through this. I will show it to you. Okay. This is the discovery packet. So first and foremost, when I was writing the original complaint for this new City of Glendale case, I did a ton of work on the UCC3 flowchart. And you can get that over at theamnestycoalition.org. Resources and documents, and then you're going to scroll down to UCC3 negotiable instruments flowchart. This is where you're going to get that at, right here. I am just going to use this other version because it's better. It's on my computer. So this is the new version, 10.1. I added all of the new updates from all the stuff that I was working on with the Glendale case into the flowchart. And the most important part of the flowchart, this wasn't here before. This is actually brand new to the 10.0 version and then 10.1. This is the most important part of basically the entire flowchart and everything I've ever done, essentially, right? So we're going to cover that first because you have to understand this first box. You have to understand the whole flowchart, but really this first box is the main thing you have to understand in order to understand why my discovery is the way it is. Okay. So a document only needs the three characteristics found in UCC 3-104, A1, A2, and A3 in order to classify as a negotiable instrument. That's the section at the beginning of UCC 3 talking about negotiable instrument, UCC 3-104. This is it right here. Just the most basic information as to what is a negotiable instrument and what is it composed of. That's 3-104, right? So 3-104 has the three sections. It has the is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2 is payable on demand or a definite time. And 3 does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. And then there's some other stuff here, right? So this is so important because I have the exact terminology here: is payable to bearer or order at the time it is issued or first comes into possession of a holder, right? Now, if you look at UCC 3-205B, it says that when an instrument does not state a payee, it automatically becomes payable to bearer, even if it doesn't say it on the instrument. And one of the great places that you can see this at is Federal Reserve notes. I don't have, I have some right here. So if we look at some old silver certificates, here's an old silver certificate. I'm going to show this to you. So here's the silver certificate. I'll show it to you. Okay. I'm going to get up and try to get real close because I want to show you something on here. There we go. So you can see that terminology. If you go back, you can pause the video. It took me a minute for it to get the zoom in there or to get the clarity of the picture. But it says there $1 in silver payable to the bearer on demand. So that's payable to the bearer, like written. It's very obvious, right? But if we look at a Federal Reserve note, I'm going to show you. This is a $2 Federal Reserve note. I collect these $2 ones. You will see, and you can look in your wallet and see the same thing. There is no information as to payable to bearer or to order. There's no information on it at all whatsoever. So what that means is it defaults to payable to bearer. And you can see that in 3-205B. You see 3-205B in the special endorsement section. Special endorsement, blank endorsement, and then this other one that I never talk about. If an instrument is made by the holder, if an endorsement is made by the holder of an instrument and it is not a special endorsement, which is defined in subsection A, if the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement. If an endorsement is made by the holder of an instrument and it is not a special endorsement, it is a blank endorsement. So the wording is a little bit weird, right? So if it doesn't state the payee, it is a blank endorsement. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone until specially endorsed. So this, like you've seen on some of my endorsements and stuff, when I was sending the drafts back to the city, I put on there, pay to the order of bearer. I put it specifically on there, right? That's like how these old silver certificates are, right? But both of these instruments are payable to bearer. This one explicitly says payable to bearer, and then this one does not state the payee. So it doesn't say payable to bearer, but it defaults automatically to payable to bearer. And how is a payable to bearer instrument transferred? Do you remember what it just said there in that subsection B? Very important. May be negotiated by transfer of possession alone until specially endorsed, right? So the reason why this is so important is because you have to have three things in order to have a negotiable instrument. You have to have these three things in 3-104, right? So number one is automatic. Even if there's absolutely no information at all specifying special versus blank, it's still blank. And that's huge. It means there's a default there. So it automatically becomes payable to bearer even if it doesn't say it on the instrument. This is so important because someone may at some point say, oh no, it doesn't say payable to bearer or to order. And it may throw you off because it has to have these three things in order to be a negotiable instrument. So they can't throw you off on this first one. The bar card shuffle ain't going to work, right? Section 2, the second thing that a document or instrument has to have in order to be negotiable, is payable on demand or at a definite time. But if you look at UCC 3-108A, it is crystal clear that if there is absolutely no information on the note or draft, it defaults to payable on demand. This is also extremely important. Like, these two pieces of information I never really talked about before, I don't think. I don't remember if I ever talked about it in the 6-part series. This is like so mind-bendingly important. This is some of the most important information on negotiable instruments that I have literally ever talked to you guys about. UCC 3-108. Payable on demand or at a definite time, right? A promise or order is, quote, payable on demand, end quote, if it, 1, states that it is payable on demand or at sight or otherwise indicates that it is payable at the will of the holder, or 2, and this is what's so big, does not state any time of payment. So that means that number 2 that a negotiable instrument has to have in order to be negotiable is also has a built-in default. So you may get the bar card shuffle of some bar card saying it doesn't say anything about it being payable on demand or at a definite time. In the case of the drafts that we're talking about for City of Glendale, for my utilities, it's very obvious that it does have this, right? But for a lot of other bills and stuff like that you may have, it may not be as clear. And that's why this is so important, because it has to have this in order to be negotiable. But everything has it. Whether it says it or not, it does have it, even if it does not state any time of payment. That's huge. So if it's just, hey, you owe me $1 and there's no other information, there's no timelines, there's no nothing, technically speaking, it still fits number 2. And it still fits number 1 as well, even if there's no. So number 1 and number 2 are always there, guys. This is so big. This is so huge. So you have to have three things for a note or draft to be negotiable, to have legal value. And two out of the three are default always there, no matter what. There's no way. I don't even know if there would even be a way I could think of that would destroy one or two from being able to be there. I don't think. I don't even think it's possible. I'm not even sure how an instrument wouldn't be payable to bearer or to order at the time it is issued or first comes into possession of a holder. I'm trying to think of an example of a time that wouldn't be the case. I literally don't even know. I have no idea. I'm trying to think. It wouldn't how if it any possible way where it wouldn't be payable on demand or at a definite time. I can't think of anything. Maybe some very, very advanced, complicated banking situation, but I've never heard of it or seen it, so I wouldn't know. I don't think I've ever seen anything ever that would eliminate one or two. Which is, I just can't even stress to you guys how important that is. It's just so mind-bendingly important. That's why I put it at the very top of the chart. I moved the whole chart down and I put this box here, right? So basically it simplifies this whole subject massively, because the only thing that an instrument or document or piece of paper or anything has to have in order to be considered negotiable is just number 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. So since number 1 and number 2 above have built-in defaults, this point number 3 is actually the only thing the instrument actually needs to have in order to be negotiable. This is literally the most important aspect of this entire flowchart. So when I realized this became essentially the basis of my discovery questions, right? It's really the basis of all questioning, of all discovery, of all litigation involving anything financial. Everything I've been describing to you so far in this show, that's really the crux of everything, right? So let's go to 3-104. And we're going to go down to, what does it say here on number 3? Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. But the promise or order may contain 1, an undertaking or power to give, maintain, or protect collateral to secure payment. So this is not, so this is where your UCC 1 comes into play, right? So if you take collateral, give, maintain, or protect collateral to secure payment, that's your UCC 1. So any sort of collateral behind the note or draft would not be considered conditional. These are not conditions. Okay, an authorization or power to the holder to confess a judgment or realize on or dispose of collateral. Not entirely sure I really understand that one. Obviously, it still has something to do with the collateral, so that would still have something to do with a UCC 1. Confess judgment or realize on. I don't even know what that means, realize on. I'm not going to try to get into all that right now. It's again, it's advanced type UCC 1 type stuff that I just don't see why we would need that for this. Or 3, a waiver of the benefit of any law intended for the advantage or protection of an obligor. Waiving your rights or waiving any benefit. That's where without prejudice comes in. If you ever are concerned about that in terms of commerce, UCC 1-308. That's actually where your without prejudice comes into play, right? A party that with explicit reservation of rights performs or promises performance or assents to performance in a matter demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. So when you guys write under protest, or when you guys write under duress, or when you guys write without prejudice, that all means the same thing. The reason why I don't like a lot of those different things that people talk about and use is because I would prefer to use the actual terminology here. I think it's just clearer and better, and it doesn't open the door for any sort of misunderstanding. Just without prejudice or under protest. Anything else, and you're kind of throwing, you're. I feel like it's a little bit more risky because it's not the clear examples given under 1-308. You can use other things or the like are sufficient, but you would have to specify, and you wouldn't specify by writing UCC 1-308 necessarily. A lot of people do that. You don't need to do that. That conversation doesn't need to be had until later at some point in time. If there's ever any question about the way you signed or rights or anything like that, it's whoa, are you under some kind of a misunderstanding here? And then you can point back to the original signature, and you can say under protest. You don't need to say UCC 1-308. You say, hey, and then at that point you would say, hey, it's got the under protest here. I don't know. Did you miss that or what? And then if they don't know at that point, then you would show them 1-308. But I don't see that. I don't see why people put UCC codes all over everything. It's not. I don't really think that's it's not necessary. It looks unprofessional. It looks like you're trying too hard. We're trying to become pros, right? So without prejudice is the one that I use the most. That's the one that you see the most. And then under protest is also an option. And then technically you can do other things, but I wouldn't personally, and I don't. So that's your UCC 1-308. That's what they're talking about here. A waiver of any benefit of any law intended for the advantage or protection of an obligor, right? So basically what it's saying is by waiving any benefit or advantage or protection, that does not make the instrument conditional and thus destroy the instrument's negotiability, right? So all of that's mostly irrelevant. You're not really going to see a lot of the stuff or really have to deal with any of it anyway. So it's not really that big of a deal. You may, in like certain situations with mortgages and stuff like that, they may have you sign things that you weren't aware of that would fit this third section, right? Especially stuff contracting you into property taxes, county codes, that kind of stuff. I guarantee you there's probably some kind of something like this, most likely somewhere deep buried in a lot of your documentation, or someone has power of attorney somewhere and you weren't aware of it and they're giving something like this away. It doesn't destroy the negotiability of the instrument, right? So really all you need to know is just this first part right here. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, right? And it's funny because they say right at the beginning of this article that the article has nothing to do with money, and then they define money in the definition section as like any medium of exchange used in a society, and then they use that definition here. So, but that's confusing, I know. But basically, the UCC 3-102 is saying, none of this has anything to do with gold and silver coin, foreign gold and silver coin. And then when they go into the definition section right after that, they define it as any medium of exchange, and then they're talking about that definition from that point forward. So when they say this, they're saying the definition from 3-103, which is any mode of exchange, any medium of exchange that may be used. Is what actually the definition they're using here. I know that's a little confusing, but that's how they're doing that, right? So the other area that they talk about this, because again, I realized doing all this that this is the most important thing, this whole unconditional versus conditional thing. And this is what I fell down on really hard on the first case that we did back in the day. So this is the unconditional promise or order section 3-106. And it has some other information as regards to what's unconditional versus conditional, right? This is really the only part that you really need. A promise or order is unconditional unless it states 1, an express condition to payment. 2, that the promise or order is subject to or governed by another record. Or 3, that rights or obligations with respect to the promise or order are stated in another record. I don't know entirely even what that means. Again, I don't think that's important. I don't think that's something that you'll be dealing with. I don't think I've ever even seen something like that. So I don't really know. Subject to or governed by another record, like some other thing or some other document or some other possibility that could open the door for conditions, I suppose. Really all you need is this. A promise or order is unconditional unless it states an express condition to payment, and then also this section here does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. Now, when you realize all this, now we can start getting into the discovery. I'm gonna jump into the special interrogatory real quick because I want to attach the thinking process of everything I just talked about to the questions, right? So here's requests for admissions. Admit that Los Angeles Superior Court has jurisdiction over this matter. Admit that the City of Glendale operates under the California Commercial Code as regards to negotiable instrument transactions such as Federal Reserve notes or other notes endorsed in blank, checks, credit card payments, etc. Admit that venue in Los Angeles County is proper. Admit that the municipal bills in Exhibit A are orders to pay, not unconditional orders to pay, just orders to pay. Making it even simpler, right? We're going to build it up. Well, basically, I tore down all the different sections, and I made micro questions for each of the individual sections, right? So I'm not having them admit that they are unconditional orders to pay. I'm having them admit first that they are just orders to pay. It's sort of like, is this a piece of paper? I feel like that's going a little too far, but you could go that far. Is there ink on the paper? I think that would almost be like offensive at that point, right? So this is about as far down as I could go. I could drill it down without feeling like I was, treating people like idiots or something like that. Admit that the municipal bills in Exhibit A are orders to pay. That's pretty easy. Exhibit A here, I put the Exhibit A and B from the original complaint attached to this so they have easy access to it. So they don't need to go and try to find the original complaint. They already have it here. Here's the bill. And is it in order to pay? Yes, obviously it is, right? So hopefully they will admit that. I won't need to compel discovery to get these kinds of questions answered, right? But let's go back here. Admit that the municipal bills in Exhibit A are unconditional. Admit that municipal bills in Exhibit A do not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of, I changed this word to currency because I put in the complaint that none of this has anything to do with money, and I don't want to have to explain how 3-102 is a different definition of money than when it's defined in 3-103 and then used in 3-104. So I just switched it to currency because I'm going to just, the word money in general is just try to stay away from it as much as possible during these proceedings. I don't want to confuse people more so than they might already be. But you can see that this terminology is just the terminology from 3-104, right? Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of, and then I switched money for currency, right? And if I were to have rewritten this, I would have removed promising. I would have just said, the municipal bill, admit that the municipal bills in Exhibit A do not state any other undertaking or instruction by the person ordering payment to do any act in addition to the payment of currency. But it's not a big deal. It's like whatever, right? But that's where I got this terminology from, right? Admit that the municipal bills in Exhibit A do not have any express conditions to payment. Now, where did I get that one from? Do you remember? 3-106. A, unconditional promise or order. A promise or order is unconditional unless it states, 1, an express condition to payment. Admit that the municipal bills in Exhibit A do not have any express conditions to payment. Do you see that? It's very simple. Admit that the name of the drawer in the municipal bills in Exhibit A is, quote, City of Glendale, end quote. So it's the drawer is the person ordering payment. 3-103 definition section. Admit that the name of the drawee in the municipal bills in Exhibit A is Brandon Joe Williams, all caps, right? Admit that all a document or instrument needs to have in order to legally classify as a negotiable instrument would be the 3 points found in the California Commercial Code, which is the California version of the UCC. This is 3-104, but it's written 3-104, A1, A2, and A3, which we just covered. Admit that there is no section of the California Commercial Code 3311 which gives any party the ability to selectively choose what kinds of notes or drafts they wish to accept. They don't have the option, and neither do I. Actually, it goes both ways. The sole proprietorship falls under the California Commercial Code as well. So the plaintiff nor the defendant, in my case, it has the ability to selectively choose what kind of notes or drafts they would wish to accept. That's actually the real truth of the matter. And if they wanted to press me on that, they could, because the thing is that the sole proprietorship falls under the exact same situation. Same thing. Admit that each draft sent in Exhibit A had an accompanying written communication. So this here, we're going into 3-UCC 3-311. Accord and satisfaction by use of instrument, right? I'm referring to B. The claim is discharged if the person against whom the claim is asserted proves. Interesting. Proves has a definition. What does it say here? Proves. Where is it at? I'm curious. It was clickable. Prove with respect to a fact means to meet the burden of establishing the fact. Interesting. Proves that the instrument or an accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. Admit that each draft sent in Exhibit A had an accompanying written communication, which is just a cover letter. Admit that each accompanying written communication with each draft in Exhibit A had a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. It's just word for word, guys. It's 3-301B, word for word. Accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. That's it. It's very simple. It meant that the plaintiff nor his owner have absolutely any responsibility as to the exchangeability of any note or draft offered in accord and satisfaction of any claim. So nothing is even mentioned anywhere in the entire Uniform Commercial Code stating that there's a duty on behalf of the person tendering payment to have to worry about the exchangeability of an instrument. That's just ridiculous. It doesn't exist. There is no responsibility on the tendering party. If they can find me something, I mean, AI isn't very helpful with a lot of this stuff. So if they can find something, great. You know, we can get into that. I'd love to get into that. Rather than just a bunch of horse shit, which just seems to be where this stuff goes. So, it's very simple. I'm just going to keep fielding all the horse shit until we finally start talking about this stuff. I mean, I don't care how long it takes. Years and years and years. It's fine with me. Admit that Federal Reserve notes are negotiable instruments. Easy. Admit that checks are negotiable instruments. Easy. Admit that credit card transactions produce an unconditional promise to pay. This one I had to word a little differently because credit cards are not in themselves negotiable instruments. Credit cards are tools that produce negotiable instruments called unconditional promises to pay or promissory notes, right? They're promissory note production tools. So that one I had to word a little differently. It produces an unconditional promise to pay. Admit that City of Glendale is not allowed to request money for satisfaction of claims, but is forced to only accept negotiable instruments. That comes from the complaint talking about the definition of legal tender from definition of legal tender in the USC. 31 USC 5103. United States coin and currency, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banks, are legal tender for all debts, public charges, taxes, and dues. And then here's the main point. Foreign gold or silver coins are not legal tender for debts. Now, I know you guys get confused about this whole foreign thing. It's actually very simple. When you read the case law that I put on the original complaint, they're talking about how the states fall under Article 1, Section 10. No state shall make anything but gold and silver coin a tender in payment of debts. One of the best places, I actually just added this case to the treatise because it's such a cool case. The 1805. It's a case called Hepburn and Dundas v. LZ. It's from 1805. I just added this whole, it's the entire final opinion is here on the treatise, right? And it's talking about the difference between somebody who's a resident of the District of Columbia versus somebody who's a citizen of a state, right? Back in 1805. And John Marshall, he was the original Chief Justice of the United States. I believe he was the first one. Let me just double check that. John Marshall. Yeah, he was one of the founding fathers. He served as the fourth Chief Justice of the United States from 1801 until his death in 1835. He remains the longest-serving Chief Justice and fourth longest-serving justice in the history of the Supreme Court, and he is widely regarded as one of the most influential justices ever to serve. When you read more about him, he's a hero. He's an American hero, And when you read more about him, he put a lot of the framework down that we still operate off of in terms of interpreting the Constitution through the judicial branch. And he has a lot of cases where he sort of formed everything. I mean, everything in our whole judicial system is basically like based off of a lot of the stuff that he was doing, right? Even to this day. And this that I'm going to read to you right now still exists even to this day. It's very important, actually. No one knows this, but this is extremely important. The question in this case is whether the plaintiffs, as residents of the District of Columbia, can maintain an action in the Circuit Court of the United States for the District of Virginia. This depends on the act of Congress describing the jurisdiction of that court. That act gives jurisdiction to the circuit courts in cases between a citizen of the state in which the suit is brought and a citizen of another state. To support the jurisdiction in this case, however, it must appear that Columbia is a state, which you see that defined that way in most federal statutes. They say, the definition of state, and it's only the District of Columbia, right? It's always kind of funny, right? But he's referring to the Republic here. Obviously, you'll see when he's talking a little bit more, right? On the part of the plaintiffs, it has been urged that Columbia is a distinct political society and is therefore, quote, a state, end quote, according to the definitions of writers on general law. This is true, but as the act of Congress obviously uses the word state in reference to the term as used in the Constitution, it becomes necessary to inquire whether Columbia is a state in the sense of that instrument, meaning the Constitution. The result of that examination is a conviction that the members of the American Confederacy only are the states contemplated in the Constitution. So they're saying constitutionally, District of Columbia is not a state, right? And that's why to this day they're still trying to, get the whole 50. So it gets confusing because you have the 51st State District of Columbia website, right? They have a whole website, Fight for DC Statehood, DC Statehood Movement, right? DC Statehood, 51st State. But every single federal statute, when they define the word state, if we go to the tax code, we're getting off on a bit of a tangent here, but this is so important. I'll go over it a million times if I have to. It's so important, right? So the definition of United States, when used in a geographical sense, includes only the states and the District of Columbia, which is confusing because it's impossible that it could be the 50 states of the Union that they're referring to here, because just like we saw from John Marshall, we have two entirely different systems, entirely two different definitions of what a state is inside that system, right? Well, luckily, they give us a definition right here, right below that. The term state shall be construed to include the District of Columbia where such construction is necessary to carry out provisions of this title. So if we just read this in normal English, you already knew this to begin with because it's a federal statute. So we already knew this before. We didn't even need to look this up, and we already knew this. But the term United States, when used in a geographical sense, includes only the District of Columbia and the District of Columbia. And that's correct. If the District of Columbia became the 51st state underneath the Constitution, they would have to rewrite all these definitions because these definitions wouldn't apply anymore because the District of Columbia wouldn't be a state anymore in federal statute. It would be a republic state. And that's why they'll never, ever, ever make Washington, D.C. the 51st state. They can do all this and they can rah, and they can collect all this money and they can do whatever they want with this. It's never going to happen because it would destroy the entire United States Code. Because the entire basis of the entire United States Code is based off of 4 U.S.C. 71. All that part of the territory of the United States included within the present limits of the District of Columbia shall be the permanent seat of government of the United States, and 4 U.S.C. 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere except as expressly provided by law. And you can see that right in the tax code. We'll go back to the tax code where we just saw the definition of United States and state. We'll go down to subsection A39, and we're going to see 4 U.S.C. 72 right in the tax code, just worded a little bit differently. Persons residing outside the United States. If any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title relating to A, jurisdiction of courts, or B, enforcement of summons. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. And then if we go back to the tax code and we go to the definition of trade or business, which is in subsection A26, the term trade or business includes the performance of the functions of a public office. For USC 72, all offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. So it all fits together like a beautiful glove when you go deep enough down the rabbit hole. None of this that we've been talking about has anything to do with the definition of the word state in the Constitution. And you'll see more about that from Mr. Marshall here in just a moment. We're going to get back into hearing what he has to say about this. The House of Representatives is to be composed of members chosen by the people of the several states, and each state shall have at least one representative. The Senate of the United States shall be composed of 2 senators from each state. Each state shall appoint for the election of the executive a number of electors equal to its whole number of senators and representatives. These clauses show that the word state is used in the Constitution as designing a member of the Union and excludes from the term the signification attached to it by writers on the law of nations. And excludes from the term the signification attached to it by the writers of the law of nations. Talking about Vattel and stuff like that. Right? When the same term, which has been used plainly in this limited sense in the articles respecting the legislative and executive departments, is also employed in that which respects the judicial department, it must be understood as retaining the sense originally given to it. Other passages from the Constitution have been cited by the plaintiffs to show that the term state is sometimes used in its more enlarged sense, but on examining the passages quoted, they do not prove what was to be shown by them. It is true that as citizens of the United States, all the way back in 1805, we're seeing this term, and of that particular district, which is subject to the jurisdiction of Congress, it is extraordinary that the courts of the United States, which are open to aliens and to the citizens of every state in the Union, should be closed upon them. But this is a subject for legislative, not for judicial consideration. So he's saying that it doesn't even totally make perfect sense, but it's not really his responsibility. He's judicial. It's actually more of a legislative issue, is what he's saying there, right? Which, again, this eventually became Dred Scott, and then that became Slaughterhouse, and then that became Bradwell v. State, and that became U.S. versus Cruikshank, and then finally we have Wong or Kim or whatever. It was kind of one of the last major cases. People always just talk about that one case at the very end, but you have to understand all through the 1800s what they're trying to say about this stuff in order to really get a full knowledge of it, right? So the word state has 2 different definitions entirely. If you're talking about under the Constitution, the word state would not include the District of Columbia. It also would not include any U.S. territories or insular possessions, such as Puerto Rico, U.S. Virgin Islands, American Samoa, Guam, Swains Islands. And then the word state in the federal statutes would not include any of the 50 states of the Union, such as California or Utah. But the word state in federal statutes would include the U.S. territories and insular possessions, which is why you see things such as 28 U.S.C. 1442, which is one of the things I'm trying to get into the Supreme Court. 28 U.S.C. 1442. This is how they removed my case from state court to federal court. If you go down to the definition of the term state court, the term state court includes the Superior Court of the District of Columbia, a court of a United States territory or insular possession, and a tribal court. Does not include a court in California. They don't want to have this conversation. They did not like this. The Ninth Circuit Court of Appeals didn't even want to talk about it. They actually just gave summary judgment. They didn't even want to talk about it. So, yeah, the words. But what's funny is the state courts that we have are actually fall under 4 USC 72 as well. So the conversation is actually deeper because technically all state courts are actually also federal courts, right? State of California is a corporation. It's a U.S. citizen. And then the courts in California operate underneath that U.S. citizen, right? So technically speaking, all state courts are attached to the seat of government and their public offices. That's why they have EIN numbers, right? And all offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. So I was fucking with the DOJ attorney and stuff like that, but I knew in the back of my head that it actually did fall under 4 USC 72, but it's just one of those things. I just kind of wanted to fuck with them, you know what I mean? So if we go back to, we got all that from the definition of legal tender. That's 31. What was it? 31 USC 5103. Legal tender. 5103. 31 USC 5103. Foreign gold or silver coins are not legal tender for debts. The reason why the word foreign is used is because this is a federal statute. It operates under areas that are under the exclusive control of Congress only, which would not include any of the 50 states of the Union, but it would include places like Puerto Rico, the Virgin Islands, American Samoa, tribal courts, certain kinds of federally registered tribal courts. So you actually have federally registered tribal courts, and then you have non-federally registered tribal courts. So that's also a little bit more complicated because it would only be the federally registered tribes that would actually fall under that definition of tribal court in the federal statute. Non-registered, non-federally registered tribal courts would not actually even fall under the definition of that tribal court section. So it's another little caveat that I haven't dipped too much into at any point in time, right? So when they say foreign gold and silver coins, they're talking about Article 1, Section 10. No state shall make anything but gold and silver coin a tender in payment of debts. But the definition of the word state in Article 1, Section 10 does not include the District of Columbia, as already said by John Marshall in 1805. So that's where this comes from. And that's how the legal tender cases of the 1870s and 1880s were born, and that's the entire background and substructure behind the case law that I used in the complaint, and it's the same case law used in the vapor money theory, and it's the entire basis of legal tender, and Federal Reserve notes are legal tender. So that's the whole background on that, right? So admit that City of Glendale is not allowed to request money for satisfaction of claims, but is forced to only accept negotiable instruments, or I could say legal tender, or I could say notes and drafts. It's all the same thing. It wouldn't include foreign gold and silver coins, which is not allowed to request money. Same thing. It's saying the same thing, right? And then here's just the damages part. Admit that the power to the apartment listed on the municipal bills in Exhibit A was turned off on January 13, 2026 for alleged non-payment. I said alleged because there is no non-payment. I've been paying like clockwork. I've never been late or anything. So I put alleged because there is no non-payment. That's just their own. They just don't understand what payment is. They have no idea. I put the definition of the word payment on one of the letters. I think it was the first one I sent them. Let's go down and see if I have it here. I'm pretty sure I have it. Pretty sure. On this first letter, I could have sworn I put it on here. Yeah. The fulfillment of a promise or the performance of an agreement. Bingo. It's the definition of payment. All right. So let's go back. I want to start at the beginning now because I just kind of skipped over all that because I wanted to kind of connect that first part. This is so in California, well, here, we'll do the letter. We'll do the cover letter. Cover letter for first set of discovery requests. So the way it works in California is the defendant can issue discovery requests immediately. The plaintiff has to wait 10 days. So I waited 10 days. During that 10 days, I did all the research, put it all together, and then served it using a process server. Didn't need to do that, but I wanted to make sure that they got it, and it's my first time doing this, so I just wanted to do it in a way that was very, very clean and very, very obvious. Hello. I wanted to say thank you for these discovery answers and also to clarify my track of thinking so that we can move through this discovery as rapidly as possible with minimal work on your end. This is my very first time ever doing discovery, so I apologize in advance if it is improper or incorrect in any way. I am more than happy to correct anything as needed. I don't want to overburden you with anything extraneous. I will enclose the original exhibits from the case we are currently in for your convenience. The core aspects of the California Commercial Code and negotiable instrument nature of the municipal bills in Exhibit A is obvious. I will have some admissions regarding that, but that is not my primary concern of this discovery. My primary concern is the nature, routing, handling, and overall construct of the detachable bottom portion of each draft. I allege, which means I place forth that of which I intend to prove, that these detachable portions are some kind of discount voucher or coupon that could fall under some section of the CCC, possibly even Division 2 of the CCC, which would be section Article 2 in the model code. I allege that each draft may very well be two separate instruments. The main portion being a bearer draft, because again, if it doesn't state a payee, it automatically is payable to bearer as long as it's unconditional, which it is unconditional. So I think the top part, it meets all the criteria of 3104, A1, A2, and A3 by itself, even after the bottom portion is detached. So I just say the term bearer draft. I just kind of made that up because that's what it is. It's a bearer draft. It's an unconditional order to pay that does not say the payee, so it automatically defaults to payable to bearer. And it can be negotiated by transfer of possession alone. I just call it a bearer draft, but that's not a for anyone that knows anything about negotiable instruments, that makes sense. Oh, a bearer draft, but it's not necessarily a term. It's not a specific term, bearer draft, right? And the bottom being some kind of discount voucher that is payable to order. Payable to order means that it does state the payee in accordance with CCC 3205A, right? And I will show you my thought process on that. I don't totally know this. Obviously, the whole point of the discovery is to try to figure it out. right? If I can figure out the routing of how the two, I think it's two different instruments. Once I can figure out how both instruments are routed independently of one another, I think I can figure out what it is, right? So here it is. So this is the detachable portion right here. You can see a little line right here, and then it goes across like this, right in between these boxes and this blue little tabby thing is where the perforation is, right? So let's go to the top section of the draft and let's take a look and let's see if we detached the bottom section entirely and only had the top section, would we have all three sections of 3-104 intact in the instrument by itself? Is it payable to bearer or to order? Well, it does not have a payee, so it automatically defaults to payable to bearer. Is it payable on demand or at a particular date? Due date 9/8/2025. Yes, it does have an actual due date. So 3-104A2 has been is there. It's accomplished. And then are there any other express conditions to payment? Looking around, don't see any payment options. That wouldn't be any sort of express conditions to payment. And then if we go back to 3-104, is there anything that states any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money? Let's take a look. Any act or instruction, any undertaking or instruction to do any act in addition to the payment of money. Is there anything like that here? No, I don't see anything, right? So as far as I'm concerned, this is an instrument even after the bottom portion is detached. Now let's do the same thing again with just the bottom portion. Now, let's say the bottom portion, this is the bottom portion, we're looking at it. Let's say it's been detached. Now, is this instrument by itself detached? Is it an entirely separate instrument? Number one, is it payable to bearer or to order? Now, this one's different. This one is payable to order. Please make your check payable to City of Glendale. The payee on this entirely separated instrument is the person called City of Glendale. You would call that a special endorsement. You would call that states the payee. You would call it payable to order. That's another way of saying the same term. It's all the same terminology, payable to order. That's why you'll see in that letter I said, I believe it's payable to order. It seems obvious to me it's payable to order, right? Number two, is it payable on demand or at a certain date? We have the same due date here, which is completely on this, even though it's entirely separated. So we do have number two. And then let's ask the question, are there any express conditions to payment on this? No, there's nothing. Please write your account number on your check. Do not attach or staple anything to your stub. Would this be an express condition to payment? Maybe. Please write your account number on your check. Let's see. Would that be does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money? This seems more like a request. Please write your account number on your check. I'm not so sure it would fit under an undertaking or instruction in addition to the payment of money. I suppose if you wanted to get really, really, really nitpicky, it's possible that this section here could fit in as some sort of express condition Well, no, it wouldn't be an express condition to payment because they'll still process it as a payment even without doing any of this. So I don't think it would fit 3-106. But would it fit 3-104? No. I mean, it would really be a stretch to say that this would fit 3-104 A3. This is just a request, basically, right? So is it unconditional? I would say yes. I would say it is unconditional. I would say that it does not have any express condition to payment, and it doesn't have any undertaking or instruction to do any act in addition to the payment of money, in addition to the payment of currency. So this is a bearer draft. I just kind of call it that. And then this is another draft that is payable to order. So this would be a bearer draft up top, and this would be like an order draft down low. I'm just making those terms up because that's what makes the most sense. Order draft is a draft that states the payee. Bearer draft is a draft that does not state the payee. I see two drafts here. That's why I want to do this discovery, because I believe by getting into the routing and how these two instruments are routed independently from one another, we can get down to the nitty-gritties as to exactly how both instruments are collateralized, negotiated, whatever is happening with them. I think the routing of the instruments will give us the information that we need to really understand the nature of each individual instrument, because I believe there's two different instruments here, right? So that's essentially what I'm trying to do. In the cover letter, I'm trying to explain to them that this is what I'm trying to figure out. And the reason why I'm explaining this to them is because I want them to be able to understand what I'm doing and not be confused. And I also, I don't want them like randomly objecting to weird things and stuff like that, wondering if it's relevant and stuff like that. I want to make sure that they can understand that what I'm trying to ask of them is relevant to this basic idea that I'm trying to basically figure out with these things, right? So anything that can help provide me with evidence that proves, disproves, or otherwise clarifies each of the strings of numbers on these drafts, as well as the nature of the main portion and detachable portion, would be very appreciated. Here are the enclosed items. We'll go through each one of these, except the exhibits. If you have any questions, concerns, or anything else, you may contact me by phone. I prefer meetings to be in person if possible. I could come to your office, or we could meet somewhere over lunch, etc. If you have any discovery for the plaintiff, please mail it to the P.O. Box, and I will ensure it is filled out on his behalf. Okay? So this is a form interrogatory general. This is specifically for California courts. They have two different types. They have one for, I believe they have one for civil unlimited, and they have one for civil limited. So one disc, I think the disc 004 is for limited cases, which is $35,000 or below. And then they have unlimited, which is the disc 001, which is for $35,001 and above, which is minus $35,001. It has instructions, and then all you do is just check box each of the questions on the form that you would like them to answer. And you'll see I only checked a few of them. I don't need a lot of this information. Some insurance information. Are you a corporation? Are you a partnership? Are you a limited liability company? I need very little information, honestly. I'm not trying to overburden them unnecessarily. I'm not trying to be massive pain in their behind. So you can see I only have a few boxes checked. I tried to only pick the ones that I thought would give me literally anything of any real relevance of importance for kind of what was going on, right? To figure out what what code and stuff that I needed to use in order to get all this done, I used Grok and I just said, what area of the California civil procedure talks about discovery procedure? And then I just, got this. And then it says here, these different areas, right? And then I just went through and I read these. So it says here, and then it has the chapters, and it has the breakdown of the different chapters and what's inside each chapter, right? Requests for admissions, depositions, physical, mental examinations, interrogatories. And I just went through and I started reading these, right? I would do CCP. I just took this and copied it and I pasted it. And then I just went here, and then you can just go to next part of code. You can see if I go back, this title may be cited as, quote, Civil Discovery Act, end quote. Next part of code. Some definitions. I read that. Next part of code. I just went through here and read this. And then if I was doing admissions, I would go to the admissions section and review the information to make sure that I had it right. But you can see these go very, very rapidly. Many of them won't even apply. Some of these longer ones, I'm not going to go through all this, but some of these longer ones you'll see only apply under very, very odd and specific circumstances. So you'll just kind of be surprised how fast you'll go through this. It is not that complicated, and you can kind of just read it all like this. I find it to be a little bit more consumable when I do it this way than when I have like a PDF file and it's just like gigantic book of codes. I personally enjoy going onto Grok or something, finding the section, and then I like this kind of little teeny little byte by byte style. I find it to be a lot more consumable, and it may take you 2 or 3 or 4 hours to kind of go through all these and to kind of look at them. But you start clicking on these, you'll notice a lot of them don't apply. They're very short. And before you know it, 2 or 3 hours has gone by. You put some music on or something, and you've gone through most of the sections. And then when you go into the actual interrogatories, then I just went back to this section and reviewed it more thoroughly as I was actually writing them. And by doing this, I was able to basically get through all this and figure it all out within a few days, 3 or 4 days, I think it was, that I was working on this, right? And then Joey also sent me some stuff that he did, so I had some stuff to look at, and then I kind of based, like for example, I would have never thought to admit that Los Angeles Superior Court has jurisdiction over this matter. I got that from Joey. That never even crossed my mind that I would even ask something so silly, right? So I added that question. Admit that venue in Los Angeles County is proper. That's a Joey question. Everything else is all me on here. And I wrote all these up manually. I just made all these manually. Now, could I have asked a million more questions? Yes. But the thing is that this is really all we need to establish. We need to establish that this is the right court. We need to establish that these are unconditional, which we've already covered that. We need to, some of this stuff doesn't even need to be here, but it's so simple and it's so easy just to get it admitted that I just wanted to get it admitted to add a little bit of structure. But I probably won't need. Now, keep in mind, you don't have to try to figure all this out on the first shot. This is just the first set. If I need a second set or a third set, I'd like to try to figure out who are all the people who are the managers over the various areas that these two instruments get routed to. That's basically the mindset behind this. And then I'm going to start deposing them and doing subpoenas. If I can't figure out how the routing is and how these things flow and where they go, then I'm going to start doing depositions and subpoenas and direct examination on the supervisors in these areas to try to fill in all the gaps, to try to figure out, so when the bottom part is detached, where does the top part go and where does the bottom part go? And then where do they go next? And then where do they go next? And then where do they go next? And then how are they processed at each individual step throughout that process, independently from one another? That will give us, or give me, or give us a very, very clear view as to what's going on with these two instruments, where they're going. And then obviously when they get routed out of City of Glendale, probably to some kind of a banking institution is what I'm assuming, then at that point I will be writing subpoenas to that banking institution to try to figure out what are they doing with this thing after it gets routed out of the City of Glendale to the bank. And then we'll get subpoenas on the external banking to try to figure out what's going on with the instrument once it leaves City of Glendale, to complete the picture of what's going on with these things and where are these things getting routed. That's basically what I'm trying to do with the discovery in a nutshell, right? So a lot of it has to do with routing and where does it go and what's happening. So this is the second section here. We have interrogatories, right? They're called special interrogatories. So special interrogatories means like custom written questions. You have the form interrogatories, which is the DISC 001. Then you have special interrogatories, which are just custom made questions. You can ask whatever you want. There are certain rules. For example, I believe in California Unlimited, which is what this is, I believe you can do 35 questions. But keep in mind, this is just the first set. I did 12 or 15, whatever it is. And then if I need more, we'll do 5 more for a second set, and then 10 more for a third set, and then whatever, and then that'll be it if I hit 35. If I even need 35, I'm not going to burden them with things that I don't need, right? So here are these special interrogatories. State the specific department, section, or individual to which the top portion of a municipal bill, meaning the main payment instrument received from a utilities customer with a detachable bottom remittance portion, is routed or sent by the City of Glendale after the detachable bottom portion has been separated. There's certain rules on how you have to ask these and stuff. That was definitely the most complicated part of trying to figure all this out. You can't do like compound questions. You can't do like certain things and stuff. So it took me some time to try to figure out how to word these in a way where I knew I wouldn't get them denied to be asked, right? You'll do all that research. I started going back and forth with AI, with Grok, trying to figure out like how would I write this, and then it gave me some examples, and I was like, wait a second, those examples are bullshit. They're all compound. And it was like, oh, whoops, you're right. So I was like, fuck, you're not even really helping me. Like AI wasn't even really that helpful on this. It was telling me to not do something and then giving me examples doing that thing. I called it out and it was like, oh shit, you're right. This is a compound, So, but by going back and forth, I was able to figure out, like, give me some examples of what a compound question would be. There's like three things that it can't be: compound, something else, and something else. And I was like, give me some examples of all three of them. So it gave me some examples of the one, gave me some examples of compound, and it gave me some, and then I was like, oh, okay, I think I get it. That's how I was able to differentiate how to word the question, right? So state the full name and the title of the supervisor directly responsible for the department, section, or individual identified in the response to interrogatory number 1. See what I'm doing? I want to establish the flow line. So the bottom portion comes off, it goes here. Who's in charge of that area and what happens with it? Great. Now, where does it go after that? Okay, who's in charge of that area and how is it processed at that point? Next. Okay, who's in charge of that area and how is it processed at that point? And then at some point it probably goes off into some weird banking or finance or who knows. And then at that point we'll need subpoenas because that's an external person. We'll need subpoenas to try to figure out, okay, once it goes out to that banking or finance or whatever, what are they doing with it? And that'll be the subpoena. Now, I believe if you're pro se, you have to get approval from the court to do a subpoena. If you're a bar card, you don't need to get approval from a court. You can just start subpoenaing people. So depending on what comes up on this, I'll need to subpoena the financial institution to try to figure out what's going on with these things once they finally move through the routing and they move to. I'm just presuming or assuming or alleging that that's how these things are going to go. So we'll see what comes up in the in this discovery, and then if they give me a hard time, I'll do compel, a motion to compel. I've kind of already got all that figured out. So we'll get that all kind of sorted out. But the whole flow line, and then where it goes, and then the subpoena, that's really what we're trying to do. And that will allow us to no longer just say shit about this stuff. We're going to actually figure it out for real. We're going to figure out what is the bottom portion, what is the top portion, where do they go, what's happening with them. We're going to really figure it out and be able to actually prove these things forever. It's really important that we get this thing, we become real professionals at this, not just kind of presume tons of stuff and assume things and just kind of goofiness, right? So question number 3, state the specific department, section, or individual to which the bottom portion, the detachable or remittance portion, of a municipal bill is routed or sent by the City of Glendale after it has been detached and stamped. State the full name and title of the supervisor directly responsible for the department, section, or individual identified in the response to number 3. Again, we just want to know what's happening with these things and where are they going and who's responsible for those areas. It's the same question over and over and over again, and then we just we want to work out the whole flow line, right? Are City of Glendale and City of Glendale collections separate corporate entities? It comes up as, quote, Glendale-GWP space Collectio space Glendale space CA, end quote, on credit card statement. So I want to know if they're separate institutions. If they are separate entities, I want to know what structure is each one. Is one a public company? I believe City of Glendale is a public company. Is City of Glendale Collections a private corporation? If so, do they have separate EIN numbers? This is, I think, important because we have to figure out how each of the individual separate entities are routing the upper and lower portions of each individual municipal bill. Because the routing may change. If City of Glendale Collections is some other different type of company, an LLC or something like that, then how are they handling and managing the instrument? Is it change the routing of the instrument? It's all the same questions again now for this other entity, right? That's why I'm asking that question. At the bottom of each, this is interrogatory question number 6. At the bottom of each municipal bills in Exhibit A, there is a long string of numbers, quote, and then here's a string. Please explain in detail what this number is. Let's go to, this is page 16. Let's go down to the municipal bill. And you can see it all the way down here at the bottom. I'm going to use my little pen because it's so cool that I get to use this. Here it is, right here. And if we go, let me turn the pen off. If we go down to each individual municipal bill, you will see that that number is the same. Let me just go down here. You'll see that same number on this document, which is a friendly reminder. You'll see that same exact number at the bottom, right? That number doesn't seem to change. That's pretty important, right? So I want to know what that is. It seems like a routing number and an account number, but I don't know. I can't figure it out. So I need them to tell me what it is and prove it. Okay. We're going back to 16. You look over your bills and everything on there you don't understand is perfect for discovery. At the upper left of the municipal bills in Exhibit A, there's a long string of letters and numbers. Please explain in detail what this means. Now, this one does change. But I didn't want to ask. So that string of numbers, you'll see it right here. right? That's the string that I wrote there. But if you look at the other drafts, you'll see that string changes. See? I believe that is different numbers. I think I checked two of them and I noticed that they were different numbers. Yeah, this one's definitely different. So I didn't ask them each string of each individual one. I just need one string because I'm sure I can probably figure it out from just the one string as to why it may be different. But it may be important. I may get the answer to that string, and then I may be like, well, shit, I need to actually find out what the other strings are as well. That would be part of the second parcel for additional discovery needed. But I'm not going to hit them with all that at the very beginning. I don't need that. I don't need that at the very beginning. I just want one to start so I can get an idea of what it is. Okay? State the purpose of the... So this is on the very back of Exhibit B. The lady put a stamp, sort of like an endorsement-looking stamp, really, on the back of the coupon, discount voucher, or whatever it is, right? So the remainder of the questions for discovery is about what in the hell is this stuff? Because this customer number doesn't match any of the other numbers anywhere else on anything. On my municipal bill, on all my other shit. I looked everywhere. I tried to compare, and this customer number seems like an entirely different number. So to me, it's like I don't really know. Do I have two customer accounts? It's a sole prop. Does a sole prop have two customer accounts? I don't know what's going on. So that's basically what the discovery request is. It's what the hell is this a different customer? It doesn't make any sense. So identify what operator is in the stamp. Identify what cust is on the stamp, and identify what batch ID refers to. And then I had one more question about the batch ID because I thought that was kind of interesting. Is the instrument described in Exhibit B bearing the stamp with, quote, batch ID QC278, end quote, processed or batched separately from the credit card transaction that was used to pay the municipal bill to turn the power back on? You see that? It's an important question because if the answer is yes, boy, we've got a hell of a fucking we've got a hell of a mess here, boys. We've got a hell of a mess here to figure out. So, could I have asked a bunch of other questions? Yes. I would rather get answers to these. It'll give me a much better idea. I don't want to just send them 9 trillion. I have 9 trillion questions, but I'd rather just ask a handful of key ones to kind of like give me a good view of what's going on. That way I can avoid asking a lot of questions that would just be kind of a waste of time. So keep in mind, you can do this first submission, second submission, third submission. You're better off doing less and then getting the answers and then doing a second submission. In my opinion, I mean, this is my first time doing this. So this just makes sense to me. If I got one of these things and it had 950,000 things on it, I'd be like, what the fuck is this? Why don't you just ask a few key things first, and then we can go from there, right? So this next section is the request for production of documents, right? It has some instructions here. I got the instructions from Joey. That's where I got the instructions. Feel free to steal them from me. I don't care. Document requests. Produce all internal flowcharts, training manuals, or corporate manuals which have any information as to how municipal bills are to be handled when they are mailed or brought in for payment. Entire manuals are not needed if they contain other subjects. Only routing, handling, flowcharts, etc. involving the municipal bills are required. If I can get something like this, then I won't have any additional questions. It will go straight to subpoenaing if what I believe is true. If we find out there's multiple accounts, we'll have to start getting into what are these different accounts, why are there different accounts. You'll see a little bit of that here, right? Produce a printout of the last 6 months for the account. This is the main account. Please include any possible additional columns or information available, such as if there are optional columns, boxes, etc., that can be printed on the printout. You know what I'm talking about? Where you print and there's like all the little boxes that show all the different pieces of information that can be printed. I want them all checked. Basically, I tried to word that as best I could. Produce a printout of the last 6 months for the account of cust, this other number, which is on the back, that stamp on the back of Exhibit B, referenced on the stamp in Exhibit B. Please include any possible additional columns or information available. Again, is this 2 different accounts? What the hell is this? You see, that's basically what I'm trying to figure out, right? Produce printouts of what other things are, quote, batched, end quote, with batch ID QC 278 referenced on the stamp on the back of Exhibit B, right? And then we'll go from there. You see, I'm not going crazy. I'm not asking them 9,000 questions. So we'll go from there. If the routing is very short and we've got it all figured out, if they give me a flow chart, then I won't need to ask any more questions. You see, if they won't give me a flow chart, then we have to do more questions. We have to start depositions. We have to start dragging people in and interviewing them and going really crazy, trying to figure out what's going on with these things. Where are they getting routed? So if they want to make it easy on me, then I'll make it easy on them. If they want to make it hard on me, then motion to compel, and we're going to go. I'm going to bash the door in and the windows in and everything until we get the answers to these questions, because we have to get the answers to these questions. We have to. It's a life or death situation, right? This is a settlement offer. This is basically the same thing that Joey's been doing a lot of that you saw. This is how Sonny won his case, his credit case, and how Joey won a lot of his cases. In the federal courts, it's called a 408 settlement letter. So all I did was I just went into Grok and I said, what is the California unlimited civil case version of a federal 408 settlement letter? That was my question that I asked. And it told me it's a California Evidence Code 1152. So I just went and read that one section. And I think it was this A here. And I just read that. And then I was like, okay. Just wanted to make sure I understood it. Wanted to make sure I had the right code. Wanted to make sure AI wasn't telling me some bullshit. And that's where I got the under California Evidence Code 1152. It constitutes a confidential settlement communication for the purpose of negotiating a resolution to the above referenced matter. This communication is made without prejudice in accordance with the California Commercial Code, Section 1308. I mean, there it seemed a little more relevant because it's like an actual formal letter, so I went ahead and just said that. But again, I just don't think you'd ever really do that. But again, this is a very, very formal letter, so I wanted to kind of add that just so that they could find that if they wanted to look that up for whatever reason, if they weren't familiar with that terminology. And shall not be admissible in any court or proceeding except as necessary to enforce the terms of a finalized settlement agreement. The issue at discussion in this case is the failure to apply or dishonor drafts duly tendered for accord and satisfaction, resulting in damages. The term accord and satisfaction, by the way, it comes from 3311. For those of you who may not be aware, UCC 3-301, accord and satisfaction by use of instrument. That's where that terminology comes from, okay? Additional discovery is needed to also inquire into the alleged discount voucher that is detachable on the bottom of each unconditional order to pay. The plaintiff and his owner are prepared for prolonged litigation. I'm ready to go all the way to the Supreme Court with this one, guys. It'd be California's Supreme Court, but I'm ready to go all the way to the Supreme Court. Absolutely no question on this case. This case is set up flawlessly. Definitely going all the way with this one. Because you guys remember, I sued in federal court, couldn't figure out the jurisdiction thing, couldn't figure out how to even get it, and then I never went to appeals. It's like one of the only cases I never went to appeals because I couldn't figure out how to do it. It just didn't make sense. I kind of fucked it up basically. I couldn't, and then I also had a lot of consideration on at that time. I couldn't figure out which UCC to use. By the way, that's also on the flowchart now. Important note number 2: the UCC is the model code, and you must use your state's version of the commercial code, or if you are in federal court, you would use the commercial code in the code of the District of Columbia, because all federal courts operate under 4 U.S.C. 72. So you'd actually go, if you were in federal court, I don't think anyone's ever done this. I've never done it. It's brand new. It's a brand new discovery. District of Columbia Code UCC. This is the one I believe you would use in federal court if you were doing federal. So here's Article 3. Let's look at 3. So it's Chapter 28 or something, or Section 28, 3-301. Accord and satisfaction by use of instrument. See, same thing. So it'd be the Code of the District of Columbia, Section 28:3-301 is how you'd write that. That's how. This is a theory, I suppose, but I don't think this is a theory. I think this is it. This is what I've been trying to figure out for ages: which UCC code applies in federal court. Even if someone messaged me and said, "Oh, Brandon, I did this and it didn't work," I still think this is the correct application, and you have to force it through appeals or whatever it takes to get it done. I believe this is the UCC, the federal UCC, the way you would do the UCC federally, because you got to think. They are dealing with negotiable instruments in federal court. So obviously there is some underlying body of law. The UCC is a model code, so it wouldn't be that one. It wouldn't be any of the state codes, right? The word state in federal statutes is always defined as the District of Columbia. The District of Columbia is basically an area under Congress. It's not under the Constitution directly. So it actually just makes perfect sense. And when you look at 4 U.S.C. 72, again, all federal courts, it makes sense. They're attached to the seat of government. They're offices that are attached to the seat of government. So those federal courts shall be exercised in the District of Columbia and not elsewhere. And so the UCC is a model code. It's not actually law. So the code of the District of Columbia is the actual law version under the District of Columbia, which falls under 4 U.S.C. 72. I'm telling you, I'm pretty much positive this is how you would do it in federal court. In state court, you don't need to deal with all that because you have the state court versions, okay? But I'm just saying all that because I'm just prepared to go all the way to the Supreme Court with this case if needed, right? I'm actually very excited about it. I believe it's a very well-structured case. I took my time to put it together really beautifully and make sure I understood each part of it and make it as clear and as concise and as it is. I don't know. I just think it's some of my best work. You know, each time I do this, it gets better and better and better. And I just kind of get this feeling, and I've just kind of had this feeling on this case that this is the first time we're actually going to be able to talk about this stuff. This is the first time I'm actually going to get any traction on this stuff. We'll see. We'll see. I'm ready to fall and down in flames and try to refigure it out and try it again some other way. You know, it's just it's the same thing over and over and over again. You guys are seeing me do this so many different ways and so many different changes and little adjustments and big adjustments, and it's just all part of trying to get the engine to run. Eventually we're going to get the engine to run. I don't know what else to tell you. As long as it takes. I think we're close though with this one. And I know I've had a lot of been very optimistic the whole time, and I really was. In fact, I'm probably more realistic now after having been beaten to death so many times. But even with that, even with feeling kind of like, well, and how about even with that, I still feel really good about this case. I still think it's going to be. It solves and handles and addresses all of the failure points of all the previous cases, So that's the whole thing. You go in, you fail, you come out. Okay, why did I fail? Figure out how to fix all that, and then just being in state court is a huge difference, because in federal court I couldn't figure out which UCC applied. I could never figure it out, and all of a sudden I go to state court. I'm doing a state court case. I know for a fact I got that figured out. And then, bam, I figured out the freaking federal section while I'm doing state court stuff. So, it's just all part of the process. It's all part of the process of understanding these things, right? So the following points would fulfill the requirements of a settlement on behalf of the plaintiff and his owner. 1, refund of all the Federal Reserve notes that have been tendered on this account since the date of the first letter of January 23rd, 2024. This will need to be paid specifically in Federal Reserve notes because that was what was originally tendered. Now, just like I said before, the sole prop is under UCC 3-311 just as much as City of Glendale is. So if they wanted to be complete assholes and say, hey, we're not going to pay you in Federal Reserve notes for this, I don't know what I would say. It all depends. It's like we would need to talk about that. Okay, well, that's what I gave you guys. I just think that's, I don't know. If they want to talk about that, I'd be willing to talk about that, because it's just, I only say that because that's what I gave them. So I'm kind of like, I already gave you guys Federal Reserve notes. Like, I just want Federal Reserve notes back. It just seems like fair. It's almost like equity at that point. I don't know. But we can talk more about that, I suppose. They've had this for, I don't know how long they've had this for, a handful of days at least, and I've got no emails, no calls, no contacts. So I have gotten no calls, no contacts, nothing, no emails about the complaint or the discovery packet yet. I'll keep you guys informed of that as we progress. Point number 2 of this, if they want to settle this, a public apology for failing to follow the California Commercial Code in relation to instruments tendered for accord and satisfaction of claims. The body of this apology would need to be agreed upon prior to signature. Number 3, a $35,001 promissory note issued from City of Glendale as the maker issuer, with all caps Brandon Joe Williams registered trademark as the payee. The instrument would need to be payable on demand. I've thought a lot about this. I mean, if they called me and they wanted to work something out, if they wanted to make it like payable, let's say in like 5 or 10 years, I'd be fine with that. Honestly, I'm willing to work with them on this. They could write me a promissory note payable in 10 years. We have a guy in one of my groups, and he actually figured out how to sell a promissory note by basically auctioning it off to like the highest bidder. And he had like all these banks coming in and trying to get a mortgage note. He had done a seller finance deal where he had sold a property as a seller finance deal, and then he got a promissory note, and then he went and sold the promissory note auction style. And all these banks came, and JP Morgan came, and everybody came, and he had all these banks fighting over this note. And then when he closed to sell the note, they tried to slip in an affidavit of lost note. And it's literally an affidavit that said that the note was lost. They wanted the note, and they also wanted him to sign an affidavit of lost note. And he's like, I'm not signing this. What the fuck is this? And the guy got all weird and like pretended as though he didn't know what he was talking about. But he had just probably had never had anybody actually like say anything to him. Because they're getting two notes basically when people say when people don't know and they just sign the affidavit, sign here, sir, and they just don't even think of it, right? So the idea of me doing that and learning how to do that would be really cool. So if they called me and they're like, hey, we're willing to settle, we want to give you a promissory note payable in 10 years, I'd be cool with that because I'd probably be able to sell it for like half its value or whatever. But what's more important to me is not the 15,000 promissory notes. What's more important to me is learning and understanding how to sell, collateralize, auction a note, and to get relationships. I would build relationships with all these different banks, and I would just do the same thing that this Pickletarian did. And I would auction off the note. I would call him up first, and I would say, hey, I have this note. And I want to auction it just like you did. And I want you to tell me more about how you did that in the process. And I would just follow whatever he did. And then I would create relationships and then I would auction the note. So I wouldn't get $35,001 for the note. I would get, 25% or 50% of the value of the note, but that would prevent City of Glendale from having to pay with Federal Reserve notes or pay with anything that they actually have out of pocket. And they'd be able to just kick the can down the road for like 10 fucking years. So everybody wins. You see that? Everybody wins. So, I'm not mad. I'm not trying to fuck them over. It's like, if you guys give me like a flow chart of like everything that happens with these instruments, we're done with all discovery pretty much. I need to subpoena any external sources. If you guys want to do a 10-year out, kick the can promissory note, that's easy as fuck. We can do that in 5 minutes. That's done. You see, this can actually be really, really simple, you see. I put payable on demand, but, if we talk and stuff, I'd be willing to do, payable at a specific date. I'm not. You'll see here, the above is also negotiable. We'll get into that in a second, okay? So point number 4, the allowance for a continuance for Brandon Joe Williams to investigate the lower detachable sections of each draft and to understand the nature of these in relationship to themselves as well as in relationship to the main draft. The settlement agreement would allow for immunity to anything that may be uncovered during this investigation, but would allow this investigation to continue to the full satisfaction of Brandon Joe Williams. I mean, 15,000 promissory notes and kind of all this other stuff, none of it's anywhere even remotely as valuable as the information. The information as to what is going on with these instruments, where are they going, how are they being processed, how are they being routed. That information is worth more than 100,000 promissory notes, 200,000 promissory notes, 500,000 promissory notes. That information is by far the most important and most valuable aspect of all of this. So that has to be communicated as that's the primary important point, right? Everything else is secondary. That's the most important aspect, right? Point number 5, a limited power of attorney that permits City of Glendale to endorse drafts on behalf of the sole prop. A non-negotiable summary sheet will be sent to the sole prop's owner each month showing the amount that was automatically endorsed and used for accord and satisfaction. Pretty simple. I mean, if they say we don't want to send you an amount every month, my response would be, well, what's going to stop you from just ordering anything you want and doing whatever you want and paying yourself whatever you want? Like, there has to be some kind of oversight. Quarterly, quarterly, you could send me a summary sheet quarterly. I feel like every 6 months would be a bit much. Quarterly would be okay, I suppose. No confidentiality agreements shall be part of this agreement, and the agreement must be entirely public and entirely transparent at all times. It's very important to me because the information as to how these things are routed and kind of how all this works is just so important. I I have to be able to talk about these things with you guys. It's just not going to work if we can't talk about that. It is by far the most important aspect of all of this. So, that's why that's there. The above is also negotiable, and the owner of the plaintiff is available to answer questions, handle concerns, and to speak about negotiations of the above. All meetings are preferred to be in person, but Zoom and phone meetings are also acceptable, though less preferable. This settlement requires very little out-of-pocket expense on behalf of City of Glendale and should be an excellent option to prevent prolonged litigation if desired. And that's everything, guys. So you can kind of see what I'm doing. You can kind of see where I'm going. And then obviously the whole point is to build out the flow line and the routing and how these things are handled. If all of this can build all that out, then we won't need a second set of discovery. If I'm not able to build all that out with this, then we will need a second set of discovery, a third set, etc., to ensure that we can build out the flow line and who's responsible and how all these things are handled and what happened with them. And then ultimately, are they sold, collateralized, traded, batched? Where's the financial aspect of how these things are used or traded? How are they financially? And that's why I put in the end there that if they wanted to settle, I would offer them immunity to, kind of whatever came up during that process. So if we find out that they're doing all sorts of collateralization, all sorts of interest, all sorts of selling and trading, there would obviously need to be some changes there. We would need to make some contractual changes. But that immunity, if they wanted that immunity, it would prevent them from getting hit really, really hard once those things are uncovered. As we uncover more and more as to how these things work and the flow lines. So that immunity might be good for them. It was kind of like me extending an olive branch, trying to get a conversation started as regards to the possibility of settling this thing and fast-tracking a lot of this information and fast-tracking getting these flow charts and these things to me so I can understand this stuff as rapidly as possible. And I just wanted to kind of show you guys here, I made a lot of adjustments to the UCC3 flowchart. So we have the box here. It comes down. This looks kind of similar. This is also another huge breakthrough that I had recently. The term bill of exchange often confuses people. Because it is typically defined as having a drawer, drawee, and payee. But the drawer and payee can be the same person. And that was a huge discovery that I had recently. So the term bill of exchange and the term draft is actually the same term. It's just typically called a draft at the state level and a bill of exchange at the federal level. So it's the same term, guys. The issuer/drawer on a draft is the company that makes the bill. This allows you to become the holder or person entitled to enforce immediately upon delivery. We've had some changes and adjustments on kind of how this works, but the overall flow line is the same. The holder or non-holder with the rights of a holder is now the person with the ability to endorse the instrument. We have the different types of endorsements, the main ones. Example of a qualified and special endorsement. If you were endorsing a draft from the IRS, it would look like this. Tender it back to the person listed as the payee. And then, it's pretty dramatically changed. This box here was changed. Something in there wasn't very important, so I removed it and I put in this, which is extremely important. This is the presumptions section, UCC 1-206. And I recommend, I don't know if I'm able to do this. I may try to make this into a poster that I sell in my store. Now that I think about it, but if not, or if I'm not able to do that, or if someone would like to do that for me, we can split the profits on it. Or you can just go to FedEx and Kinko's, something like that, and get this printed up. and get it on your wall, because you should be looking at this flowchart all the time. This should be the centerpiece of everything we're doing, literally. So there you go, guys. I hope that helps. It gives you an idea as to how to get the questions that you'll need to figure out the things that need to be figured out. You want to look over the bills, ask about anything that doesn't make sense to you, ask about any strings of numbers, strange strings of numbers. Look up the various sections, have AI help you find those sections, and then just read them. Yeah, that's everything. It only took me, 3 or 4 days to put all this together, maybe 5. I spent a whole day just trying to figure out how to ask those special questions without them being compound or whatnot. Just writing them in a way that would not get them denied. That took me a huge portion of time. That was probably the hardest thing, frankly. That was probably the hardest thing of all this. Everything else was pretty easy. So there you go, guys. I hope this is very helpful for you. I apologize. I normally get these videos done sooner. I wanted to do it, but I got sick last week. I had to cancel a couple shows, which I haven't done a lot of shows in a long time, which is kind of sad. I'm going to reschedule those shows. We got some shows this week that are very exciting. And then the Epstein thing just kind of really bummed me out. I've been kind of bumming. So, this is my first time kind of getting back into it, kind of getting back on the swing of things. I'm doing some dietary changes. Start doing a lot of vitamin C, just a lot of stuff happening over here. So, get some shows popping here soon. We'll see what happens with this. Oh, one other thing, for those of you who have not seen yet, if you go to the shared folder, and you go to the notice of case management conference, you'll see that the first hearing, this first hearing has been scheduled. It may change, but it's scheduled for August 4th, 2026 at 9 a.m., Department A, Burbank Courthouse. So just keep in mind that could change. I don't really know how volatile that is of a date, but just keep in mind, I promised you guys I would let you know when we're having hearings and stuff like that so you guys can come. Some people want to fly in. Got a lot of people who want to fly in, so I don't know how that's going to work. I would probably recommend you wait until maybe a week or two beforehand to book any flights, anything like that. But yeah, you guys are more than welcome to come out. We'll probably have like a lunch afterward or something like that. Try to find a place that has like a big, huge table or a big, huge room. The last time I had a hearing last year for the small claims case, I did a very, very small announcement at the very, very last second because I just wasn't sure if I wanted to do all that because it was already hectic enough in my head. We had about 10, 12 people show up. We ended up getting lunch afterwards. So with me announcing this stuff way in advance, I mean, it's definitely possible we could pack the whole courtroom to the point where, people can't even get in. It's very, very possible that we're going to be in that situation. So I'll be letting you know anything that changes, anything that happens. I'll let you know as much in advance as possible. That way you guys can make plans or whatnot. And I hope to see you there and we can get some lunch afterward. And there's very strict guidelines on recording. So you have to be sure to, look at that. And then obviously you can't get rowdy. You can't be yelling, doing stuff because that would make it difficult for me to get the hearing done. I'm trying to actually get this thing done. So as long as you're respectful and you don't violate any of the rules, then you're more than welcome to come and have us a packed courtroom, and maybe have a lunch or something afterward. Okay, guys. So I hope that helps. I hope this helps. You're welcome to take any of this stuff from my files and copy it or paste it or do whatever you want. You're welcome to use the same questions. This is not some kind of copywritten material. You are not allowed to use the Williams & Williams law group logo. Obviously, that's just stupid. You cannot use that. No one is allowed to use that. But everything else is fine. I don't have any other copyrights or any other concerns about using these things. The whole point of me making all this available for you is to give you ideas and to help you. If you're being sued, you can move into discovery right away, and you can start issuing discovery requests right away with your counterclaims and stuff like that. It's the same thing. It's counterclaim, and then you're just going to start asking all these same questions, try to figure out what's on the bill. Where does the bottom part go? Where does the top part go? Where does it go next? Who's the supervisor? If you need to depose them to figure out what's going on, how are these things processed? If you can't get answers, you're going to start deposing people. And then whenever you see it disappear or magically go into a computer system or something like that, where is it going after that? And then if it's a bank or a banking institution or a credit union, bingo, you've started to really nail something. And then you're going to be writing subpoenas at that point to force that banking institution, financial institution, to give you information on what happens to this lower portion or upper portion once it's received by them through this computer system or mail or whatever it is. And you're just going to build out that flow line. And the more people we have doing this, the faster we're going to figure out how all of this stuff really, really works for real. We need to really prove everything, get it all locked down. We need subpoenas. We need admissions under penalty of perjury. We need really, really solid evidence so that we can kind of put to bed what these two instruments really are, how they work, how they're different, and then how it benefits us, and how we can work with these various institutions to make sure that these things can work for them, it can work for us, and we can all win. Okay, guys? I hope that helps. I hope you enjoyed the video, and I hope you guys are doing well, and I will speak to you soon. Bye-bye.